Okay, we're going to revisit our income tax guru, Peymon, and he made a surprise appearance, if you will, and we had actually an impromptu debate the other night. Artie and I were doing a live stream going over my video on him, and to our surprise, Peymon appeared for an impromptu debate on the live stream. And that's what I'm going to be addressing tonight is some of the things that we didn't get too much in depth at that point. But I want to suggest that if you don't know who Artie is, you need to check out his YouTube channel, Artie's Corporate Fiction. He's a wonderful host. He's an attorney. He does breakdowns of sovereign citizens and First Amendment auditors. He's very entertaining, very knowledgeable, and I know you will enjoy his videos. So please check out his channel. Now, Peymon, we come to find out, made a video the same night that we did this live stream. So I wonder what Peymon said in his video, because as you know, Artie and I think that pseudo-lawyers should be ignored, and a person should really seek out a professional when dealing with income tax and things like that. So let's listen.
Do you need to get a law degree or learn a bunch of legal lingo to lawfully and safely not have to file and pay federal income taxes anymore? I will answer that question for you tonight with an affirmative yes.
Whoa! Peymon, looks like you're waking up. Yes. So let's continue. Okay. Now everybody that saw my video knows that Peymon makes up basically his own definitions, especially of the United States, because Peymon wants, no, he needs to convince people to abandon their long-held knowledge for 62 to 100 years that the United States means the 50 states. Now, without this, Peymon could not sell a $9,900 package. So let's look at this right close here. The term United States. Well, now united, we know what that means, and states, that's plural. So we all know for 200 years what the United States means. And when used in the geographical sense, it includes only the states. That's one thing. That's a plural. That's more than one thing there. The states and the District of Columbia. So there's two things, or two categories that make up the United States. The states, plural, and there's 50 of them today, and the District of Columbia. But then Peymon goes down and focuses on the term state, singular, to mean only the District of Columbia. But it says that it shall include, and we covered this includes and including things, so I won't go into that, includes the District of Columbia, but in a limited sense. There's a limitation of when it's to be included, and that's where the construction is necessary to carry out the provisions of this title. Now, Peymon presented some court cases and some reasoning why he interprets it the way he does, and we're going to get into that right now.
It applies to 50 states because Gould versus Gould, a U.S. Supreme Court case of 1917, clearly said that in the understanding, interpretation of tax laws, statutes levying taxes, it is the established rule not to extend their provisions of tax laws by implication beyond the clear import of the language, or to enlarge their operations so as to embrace matters, tax matters, not specifically pointed out. And most importantly, in case of doubt, they are construed most strongly against the government and in favor of the citizens.
Okay, they're construed strongly against the government, but when in doubt. Now, is there any doubt that for 200 years the United States has meant all of the states that were united? And now today there's 50 of them. Is there any doubt about that? So Peymon is trying to tell us that if somebody comes up with a wacky definition of United States, that wacky definition is supposed to be looked at in favor of the person making that wacky decision instead of the government's definition. And there is no doubt. Now, of course, Peymon puts a lot of doubt into his victims' minds, but there is no doubt that for 200 years, United States has meant all of the states that are united. So let's continue.
Case of Hoover versus Allison Company versus Yvette, 1945, and the relevant language, this is all included in our petition to Congress, okay? So in this case, this is very important, okay? They're talking about, Philippines, is it part of the United States in this sense or not, okay? Because this was a tax case, by the way, okay? So they're talking about imports. So this is a tax case, okay? If transferred from one state to another. The term United States, highlight area, may be used in any one of the several senses. Oh, really? Interesting. It may be merely the name of a sovereign occupying the position analogous to that of other sovereigns in the family of nations. That would be like America in relation to France, Italy, Germany, and that's what they're referring to. Number two, it may designate the territory over which the sovereignty of the United States extends. That's right. Washington, D.C., Guam, and other territories, that could be other United States when they use that in the laws. The third one is the one everybody thinks about.
Whoa, what did you just say, Peymon? The third one is what everybody thinks about. Now, don't you think that the legislature, when they put a term like the United States in a statute, that it's going to be reflective of what everybody understands it to be instead of your obscure definition? Let's continue.
Or it may be the collective name of the states which are united by and under the Constitution. See, this is the key case also. We always assume United States and the laws mean the 50 states.
Yeah.
Supreme Court tells us no. And guess what? Juan is right on this point, that we must look at the construction and intent and language to see that what they do, and you see that this all limit. The United States that the income tax applies is the second one. The territory.
Well, that's how you're interpreting it, though.
Yes, that is how I interpret it.
Okay, fine, but Juan and I are interpreting it as the third one.
And not only Artie and I, but everybody but Peymon and his victims interpret it that way. The legislature interprets it that way. The courts interpret it that way. Only Peymon interpret it differently. Let's continue.
Very important case. And I'm going to have to come back to Gould versus Gould more than one time, perhaps, because one of the things that Juan does, he gives a very short shrift to these Supreme Court cases and what they say, what they mean.
Hell yes, I do. I've got over 40 years experience. I've been educated, trained, and written thousands of briefs, briefed thousands of cases. I understand how to look at a case, know the issues, know the fact circumstances, and know how things are being said. I don't take them out of context. You can't take a sentence out of context.
Okay. First of all, this case of that's before us right now, before Gould versus Gould, is very important. This is a case of Meese versus Keene, 1987 case. This case was about political propaganda. No doubt about it. I'm going to keep playing a video so you can see that. That is true. However, the court makes very clear that, number one, in any statute, I think we all agree that Congress has a definition to make any kind of definition they want, but it is axiomatic, which means self-evident. The word axiomatic is a logical math term. It's self-evident that the statutory definition of a term excludes unstated meanings of the term. That's very important. You cannot just lightly just shrug off the Supreme Court words. I mean, when Juan, you just called it cherry picking.
Yes, cherry picking. Cherry picking is taking a sentence out of context and trying to apply it broadly. In other words, Peymon, you're saying that this one sentence, taking out of context, applies to everything else that's written in statute. Well, let's look. Cherry picking is taking things out of context. Let's put this in the context in which that statement is made. Go up one and it says, go up this previous sentence. Nor do we agree with the district court's assertion that Congress's use of the term political propaganda was a wholly gratuitous step designed to express the suspicions with which Congress regarded the materials. So in other words, the Supreme Court's looking and says, hey, district court, you're making an assertion here that you're stretching the definition, you're speculating that the people are going to interpret this differently than it's in the statutes, and they're going to be confused. So they say it is axiomatic that the statutory, now what statute are we talking about? We're talking about a statute that governs political propaganda. So the definition in that statute of the term, and what term are they talking about? They're talking about the term political propaganda. Excludes unstated meanings of that term. So that sentence is referring not to every statutory definition that's ever been made. It's referring to the statutory definition of the facts of this case. And that statutory definition of political propaganda. This statutory definition of political propaganda excludes other meanings. So see how he tries to cherry pick something out of context and shove it and try to shoehorn it into his narrative to support what he's saying. But it just doesn't work that way. None of it works that way, Peymon.
Of the Supreme Court case. This is what everybody in quotes the Supreme Court. This is what we go by. So that character assassination.
That's what you go by for this case and for this statutory definition, not for every case from here on out.
Assassination cherry pick.
Now, this is very interesting because this is what the court says. Like I said, the district court had made a decision, came down and made an assertion that, this definition of political propaganda is going to confuse people and they're going to try to interpret it some way else. But the Supreme Court looked at it and said, well, district court, your reasoning is contradicted by history. This statutory definition of political propaganda has been around for over 40 years, for over 4 decades. And we can presume that the people have sufficient understanding and knowledge to know what political propaganda means. And you can't just arbitrarily expand on what that means. So let's look at this again, and let's change a couple of words about it. Let's say that this would say, the statutory definition of the United States has been on the books for over 200 years. We should assume that the people have a sufficient understanding of how the term the United States is used. Now that's the way you look at it. Let's continue. I know you believe it. Okay, here I am talking directly to Peymon. I know you believe in the person who taught you this stuff, but they didn't know enough to tell you.
No one taught me this stuff. I researched it all myself. But let me address
just a minute. That's the person I'm talking about. Your teacher is not doesn't have the necessary knowledge, which is the teacher is you, to understand how to construe statutory construction. This is the problem that most pseudo lawyers have, is they're self-taught. And they're being taught by a person who's ignorant in law and court decisions and legal procedure. So that's the point I'm making here. And what you're doing is you're making it where it would be absurd, and it's not absurd. You are making it that way because of your misinterpretation of how statutory construction works. Okay, so let's see. I'll let Peymon close it out here. Okay, Peymon, tell us what you think.
Do you need to get a law degree or learn a bunch of legal lingo to lawfully and safely not have to file and pay federal income taxes anymore? I will answer that question for you tonight with an affirmative yes.
Yes, Peymon, you're absolutely correct. You have to hire an attorney.